So, starting with Dr. Kwesi on Zoom. Doc, the elections have come, and I am still in our election headquarters, shirt. We were hoping that a week after the elections, we'll do away with them. But it doesn't appear we are likely to stop discussing the elections on December 7th. What do you make of the situation now, where the NDC stands particularly? Hello, Professor Enin. Okay, so Rhoda, from where you sit, the NDC had indicated clearly, so Professor Enin is back. Professor Enin, I was asking, how should the conversation be had going forward, looking at where the NDC stands, that this is a fictionalized, flawed elections, and they have issues with some of the parliamentary as well. Both parties have issues with some of the parliamentary.
Well, Samson, I think this is a much bigger conversation than just the NDC and the MPP and the manner in which the election results have been presented. I think this relates to institutional efficacy, the manner in which communications around critical national issues are done, the packaging, the content, and the presentation. Let me start by discussing the issues around the voter registration. There were issues around the presentation leading to and relating to the numbers themselves and the rationale for a new register. That created the original misunderstandings between the parties, the role of the EC in the presentation of those content. Then came the actual registration, some of the violence that we saw, and what we've discussed there much earlier on, issues as to whether, more ID cards were printed than were necessary. Once more relating to how national issues are communicated in a manner that generates trust and that builds trust. So it is within this context of a heightened sense of suspicion and the delivery of what we all agree are public goods. That is the holding of credible, inclusive, trusted elections by an institution that we all as Ghanaians have hailed as credible. Then the voting itself. I mean, I had the privilege of seeing almost about 90 polling stations, randomly selected on that day. And there was one particular polling station and the behavior of the EC officials that was so exemplary. The pedagogical manner in which the process was explained, the innovative manner in which lines were drawn with a stick on the ground to distance voters, and when two frail, elderly, blind people came to the polling station, the manner in which the Braille voters' ballot were displayed clearly for people to know that these were special people and that their ballot even looked different. The process ended. We came back later on and I randomly saw some of the counting And it was actually a near celebratory process. Now, part of the challenge was the insistence of the 24-hour declaration, which right from the word go, there were indications that, look, probably we should give ourselves a little bit of a leeway because of the tensions, the mistrust, that anything that did not fit into what that institution, the EC, itself had promised the people of Ghana could then lead to suspicions and to questions. And of course, we all know what has happened subsequently. The issue of the arithmetics as to how right they are and as to how much they would have shifted and changed the eventual outcome, for me, though important, is not the most critical issue. Some of the critical issues relate to why and how that multiplicity of different figures have come about, and more importantly, the signal that it sends to the generality of the Ghanaian public, and by extension, our trust in the dependability of that institution, and which is most unfortunate. But it's not only the EC's actions that I think we ought to, almost a couple of weeks after the elections, begin to discuss. I think some of the videos that we've seen and your own station showing us the direct pointing of guns into crowds and actually shooting, leading to the terribly unfortunate loss of lives, must raise questions about our capacities for crowd control. And something over the years, I think we've spoken about the Ghana Police Service or our uniformed services capacity for crowd control. And I think once more, the collation process and then the loss of lives have demonstrated once more that we need a much better approach and training in how our uniformed forces relate to this. So we've reached an unfortunate impasse in which the voter base have done or have performed their responsibility as citizens. I think the levels of violence, disruption were fairly low. Where the challenge lies now relates to the sanctity of what has been published, the court injunctions, the gazetting of those results, and the subsequent mistakes, tensions that are beginning to arise. So I think there is a responsibility, first and foremost by the two parties, but also by us as citizens to say, what do we want and how should our institutions behave? And I think therein lies the lacuna in which we have boxed ourselves. Two more points from me, Samson, very quickly. One relates to the peace agreement or the peace accord that was signed prior to the elections. And this is because I'm coming back to that because it relates to the two major political parties. The signing of that accord ought not to have been perceived as an end in itself, that it was just a first step to a lot of hard work to ensure that the 6 points that the two parties had voluntarily signed on to, and here the word voluntary is very important, they had voluntarily signed on to. Oh. Now, that hard work and whether it transmitted down does not seem to have been done. The second point, and probably we can come back to this, the second point relates to the usage and abuse of the word peace in our country right now. Almost every individual or institutions or groups are talking about the need for peace. And it raises a fundamental question as to what type of peace we are looking for. And how do we attain and achieve that kind of peace? Let me make this point very clear. Peace is not a common good. Peace is something that must be striven for to attain and achieve based on shared values and shared norms, underpinned by unshakable principles, that this is where we need and we want to get to. When we talk peace, I think it's become a very rhetorical, flash in the pan, usage of that word or misuse of that word, because we need to be heard to be talking peace.
Okay.
Finally, is the role of who are the institutions, or what are the institutions that we have now that enjoy the credibility that can mediate between the institutions that are making Ghanaians feel insecure and tense. And it's quite unfortunate that probably here I will highlight the personal role of the chief imam and his office. They seem to be the only institutions, or one of the few institutions, that have managed to rise above the fray and have kept quiet so far. So we need to find institutions with the credibility, the ability, and the neutrality to be able to elicit a change in behavior. And I like the word used by Kwame about risk communication.
All right.
Risk communication will have to deal with attitudinal and behavioral changes.
All right.
And we need to begin that process.
Right.
Now.
So, Professor Nina, I need you to respond to this in 1 minute, and then I'll go to my other guest. So, you started from how, the mistrust began, the registration, new register and everything. But as we know now, ultimately, there are no issues with the register.
No.
Yes, the register has not brought us any problem as in the elections. So now that what you refer to as a tension, which is leading almost everybody, leading to the chorus of peace, 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 and directed at the NDC, would you say that, of course, the police in Accra has stopped the NDC from embarking on demonstrations that it wanted to do? Would you say that stopping the demonstrations and also the NDC itself, if it activated the processes of the courts, rather than being on the street, which is their rights to demonstrate, would be an effective way of dousing the tension? In 1 minute.
No, I don't think so. I think the behavior of the police in the whole process is adding fuel to the suspicion, the anger, the frustrations. And I think this has gone beyond the NDC as a political party. I think there are structural, fundamental issues that people are joining these demonstrations. Two is the NDC's ability to control the demonstrations themselves. And therein lies my worry about the increasingly expanding demonstrations in terms of numbers and geographical spread. What are the possibilities that these demonstrations can be hijacked and then transformed into something else? And that is why I'm asking for institutional bodies with the credibility and the neutrality to begin the process of mediation and negotiation, placing Ghana in the center of this negotiation, that it is our collective coherence as a nation and our ability to be each other's keeper that must drive our efforts to acquire this national power that we are looking for. Ghana must be seen as the enterprise around which we cohere and we work towards the stability.
Okay.
That we're talking about.
Rhoda, from where you sit, let me have you speak briefly, and Kwame Asiedu briefly take your minds on this. Can the NDC have what it is asking without recourse to a court? And if that is the case, what will the demonstrations serve? Rhoda.
Thank you very much, Samson. I think it's a good question. The issues that we really have to focus on are, one, what exactly is the NDC seeking from these protests and also from the petition? Because I think if we're able to pin it down to what the specific issues are, then it helps a lot more in terms of what the path to resolution should be or should look like. First of all, if you look at the issue of Techiman South and the petition they presented or they showed on Friday or Thursday last week, this week actually, I think a number of issues that they raised about the collation, the processes, and some of the challenges that they believe occurred, and also the outcomes. The Electoral Commission, on the other hand, believes, so far they haven't come out yet, but if their silence is anything to go by, then I think the implicit assumption is that we've done a job, we think we are fine, we've moved on. The NDC obviously is not fine with it. Now the issue is what specific challenges are they raising? And again, like I said, yeah, issues about the process and the outcomes. They say there wasn't a collation. They are making a point about the non-declaration of a candidate and all of that. Some of these issues are issues that you cannot just sit down and say, okay, we've agreed between the Electoral Commission and the NDC. These are the issues, we are going through it, and that we've agreed that we are going to resolve it. There are also legal processes that have to come into play. If, for instance, there's been a declaration, for instance, and there's been gazetting of a winner for the elections, can the Electoral Commission now just sit down on the table with the NDC and say, this is what we've done, but now we want to go back to the process and resolve A, B, C, and D? I think there are some of the issues that they can discuss, issues about whether there was a coalition or not. There can be clarification. Definitely, the NDC had people on the ground in the constituency. The Electoral Commission also had people who did the work. What really transpired? I mean, I've been trying to get the facts from our observer who was also at the collation center. Definitely something happened. What is the real issue with the process that makes it unacceptable to a party? If those issues can be clarified by the Electoral Commission, fair enough. But I think there are other aspects that probably might be difficult, legally speaking, for the Electoral Commission to just say, meet them and resolve. So maybe in that case, that's where the other measures can be triggered. But if the Electoral Commission is able to provide some answers to some of the issues that they are raising, I think it will be helpful, even if it's not just sitting down with them at the table, but just providing clarification, because so far, a number of issues have come up with this Techiman South issue, but we are yet to hear from the Electoral Commission. What is it that the Electoral Commission is not communicating, not just to the NDC, of course, but also to the public, because the Electoral Commission is accountable to all of us. So a party is contesting a number of issues. What happened? What didn't happen? What is your clarification on all of these issues? Just providing information to the public so that at least we're able to understand what happened. And then if these are not satisfactory to the party, of course, then they can go a step further. But I think the point I also want to make is whether, I mean, before the petition, the party had raised issues with the process through other mechanisms, because what we saw with the march or the protest by the MP seemed to suggest that we've tried other means and these have not yielded much, and therefore this is another avenue. Like we know, elections have always been, often been contested in this country. In 1992, it was to the extent that a party boycotted the whole presidential election just because they had issues with the parliamentary elections. And then there have been other cases, other subsequent parliamentary elections where issues have been contested. So this is not the first time that we are having challenges of this nature. In 2012, if you look at some of the issues that were raised in court, some of the same issues have come up about unsigned pink sheets, about collation challenges and all of that. But the issue is that what avenues exist for us to address these issues? Have we exhausted these avenues? Were the outcome satisfactory or not? If not, then can we do that? Because I get the impression that the NDC has done everything that they need to do and they are not getting a hearing. But I'm not sure if they've indeed exhausted the mechanism. So before probably there was even a petition or a work by members of parliament, was there a formal petition to the Electoral Commission, even at the parliamentary level, at the constituency level? And what were the outcomes? Did the party, the EC, address these issues or not? Before maybe we move on to the different layers. So it's not clear what exactly had been done, apart from, of course, the open or public voicing of these issues on various media platforms. But it's important that we don't lose sight of the matter. Both the NDC and the Electoral Commission, we all don't lose sight of the critical or the fundamentals of these issues, what really we are contesting and the mechanism for contesting these. Ultimately, we are also looking at the peace and the stability of the country. Right. Because at the end of the day, there's a country that we have to govern. People have to move on. But before we move on, what mechanisms are we using to seek redress? Seek redress to our grievances.
Thank you. Kwame, the NDC are very clear on this subject. They say in the petition that they tried to submit to the Electoral Commission chairperson, Jean Mensah, they've actually had Jean Mensah write to them, or there's been a circular to that effect that it was not deliberate, that they were not received, and that they had given too short a notice, and so she was not in the office to receive their petition. However, she's ready and willing to receive their petition if they will deliver it, and then she will respond to their petition. Now, in the petition, they said that they have received and studied a petition from their parliamentary candidate and winner of the Techiman South parliamentary election, Christopher Bayere Basonte, on the happenings in Techiman South. That in the presidential parliamentary elections conducted nationally on December 7, the returning officer for Techiman South constituency in the Bono East region could not collate the results for both the presidential and the parliamentary candidate after the polling polling stations results had been counted and all ballot boxes sent to the collation center in accordance with CI 127. The returning officer delayed the collation exercise with the explanation that there were problems with the results of 2 polling stations out of the 266 polling stations in the constituency. Long after midnight, the agents for the NPP candidate also raised issues with 3 other polling station results before collation could commence. The returning officer later announced a change of collation center from the community center to the Ahemfie Hall in Techiman. At the collation center, the parliamentary candidates, their representatives and agents agreed with the returning officer to resolve the outstanding issues relating to the 5 polling stations that were raised by the returning officer and the agents of the NPP candidate. During the discussion, there emerged serious differences between the agents as to how to resolve the outstanding issues. The regional director of elections, together with his deputy, advised the way forward in resolving the controversy. While the agents were doing all they could to resolve the issues, armed security officers in police and military uniform stormed the center, drove off the agents for the NDC candidate from the coalition room, and in the process brutalized one of them, leaving only the election officers and the NPP agents in the room. The sight of the NDC agent bleeding and moving in their direction, they raised tension among the voters who were waiting outside to hear the results of the collation. In attempt to ascertain what had happened to the agent, the uniformed men opened fire indiscriminately, killing 2 persons on the spot and injuring 9 others, one of whom died a day after admission. Due to the state of insecurity at the center, as a result of the shooting incident, the NDC candidate and agent had to advise the voters to leave the center before taking cover for themselves. No collation could have taken place that day in such circumstances, and neither the NDC candidate nor any of his agents were informed or invited for the purpose of collating the results of the presidential parliamentary election at a later date. To all intents and purposes, no collation could have taken place, and no collation took place in accordance with CI 127. That in Jean Mensah's announcement of the presidential results on the 9th of December, as the returning officer, she admitted that with the exclusion of the presidential results, she admitted to the exclusion of the presidential results for Techiman South constituency from the total tally. So they are reliably informed that the NDC candidate, bottom line, their candidate won and there was no coalition. There could not have been a declaration, and to that extent, they want a number of things done, and this is what they want to be done. They demand that the EC causes to be collated the Techiman South constituency parliamentary and presidential election results from all the polling stations with immediate effect, and then they want that pursuant to Regulation 49, the endorsed rate, gazette notification, and notice to Clerk of Parliament be amended accordingly to reflect the true state of affairs. Where you sit and observing the processes so far, seeing the footages you have seen so far from Techiman South, and I'll be speaking to some of them very directly shortly, what do you think is going on?
Samson, for someone who always relies on numbers, the first thing I would say is that the whole Techiman South debacle points to a people who do not take attention to details seriously. And why do I say so? For you to do any correlation in an election, there is what we call a primary source document, which is the counting that went on at all polling stations. That is the primary source data. That is where you get your data and put together to get the composite data for the constituency. To the best of my knowledge, the NDC and NPP had agents at all these polling stations in Techiman South. To the best of my knowledge, we are not being informed that at any of these polling stations, these said agents raised issues. The issues were subsequently raised at the collation center for those 5 polling stations. The question I ask myself is, what does our law say? Is our law not clear that if you want a recount or anything, it should happen at the polling station? Is it also not true that if you refuse at the polling station, it should be indicated? So when you get to the collation center, the officials at the collation center can then decide to accept the verdict from the polling station or allow another recount. Were these processes followed to the latter? If they weren't, or if they were, the other thing about attention to detail is the fact that the
first of all, the NDC is not asking for recounting. So yes, that is out. Initially, yes, that was the impression that they were asking for a recount. That's out.
No. And that's what I'm saying, that so we don't have issues with the source data because nobody's asking for a recount. That was exactly the point I was making. So the source data is credible as far as the two parties are concerned. So how difficult then is to have 266 pieces of source data that you are simply adding up to see, based on the composite aggregations, which one is in the majority? How difficult can that be? That should result in the death of 3 people. So the question I ask myself is, the NDC currently is saying there should be recollation. They have put out their set of primary data at a press conference saying this is the tally they got. The NPP also has its source data. The Electoral Commission has theirs. as it stands now, the indication we all have is that the result from Techiman South has been gazetted. So ultimately, if it is correct that once gazetted, the next line of action is the courts, how difficult is it for these three sets of primary data to go to a court, or even if it's the EC, for an an audit to be done, one, of the veracity of the documents, just in case any of the parties has altered their primary source information, and two, the veracity of the collation of the Electoral Commission. Let's remember the Supreme Court in 2012, an audit was ordered, and therefore a court can do it again. So why don't we all save ourselves the cacophony going on and just get these three things done? Is it beyond us? Okay. And that is why I, for one, I am struggling with this whole issue about Techiman, because I cannot fathom how 266 pieces of primary source data cannot be put together and should lead to the death of three, especially when none of the primary source data is in dispute for a recount to happen. Right. So I think the NDC are asking for stuff, and rightly so, because if they are contesting the result, they can. But the solution to what they are asking for is very easy to arrive at. Unless, of course, either the MPP or NDC is saying they don't have all the source data, or the Electoral Commission is saying that it doesn't have its copies, that the Techiman South Electoral Commission office has to forward to them. If all three are available, I don't even see the problem, because the rest of it is arithmetic. Okay. And if as a country, after 60 plus years of independence, we cannot get basic arithmetic of 266 source data correct, then we need to be looking in the mirror and asking ourselves some very, very nasty questions. All right. Thank you, Kwame. Now, let me come to Kofi Abuchi. And from what you have followed so far, the NDC believes that the matters can be resolved at the Electoral Commission. And that's why it is pursuing through a petition. If you hear the consistency of their communication, as led by the General Secretary and others, is that the EC is capable of resolving their issue. Their presidential candidate won the elections in that constituency. They say they have put the pink sheets together and their candidate has won. Unfortunate though, from the NDC, we have had as many as 4, 5 different set of figures. But in all, their candidate would have won. From where we are now, at the point where we are, can the NDC get what it is asking? And should it continue the way it is proceeding?
Okay, so there are multiple layers of your question. Just to put things in perspective, there are 3 remedies that are available to a political party upon the declaration of results. If the political party feels aggrieved by the outcome of the declaration, the first one is political. There is a political remedy, and they're not in any order, but these are the 3 options, the 3 remedies. The first one is political. The political is what we have seen the NDC manifest in recent time. The political usually is in the character of protestations. This is not intended by the Constitution or the framers to be an electoral remedy, but it happens to be an electoral remedy that can be embarked upon by political parties as a pressure instrument, and particularly also to get the country not to move on. So it's a political strategy. After elections, a country can move on. And when the country moves on, the complaints of a political party becomes a distant cry. Lots of people would have moved on with their lives. We are ready for the country to move on. And so the political strategy is used by political parties to keep the country still in the process of the elections and to keep us in the electoral throes. So the political remedy can be strategic and can be effective if properly harnessed. The second one is administrative. The administrative remedy is a remedy that is available to the political party to appeal to the administrative senses and the administrative judgment of the Electoral Commission to, as it were, review a few things that may have happened which it's not happy or satisfied with in its favor. So the political party can request recounting, can request recollation, or any other administrative action on the part of the EC designed to, as it were, review the outcome of the elections and the declaration which it feels aggrieved by. The third option is the legal. Again, not in any particular order. So any of these things can be simultaneous.
So, for example, before the third option, have we not gone past, and that's the essence of my question, have we not gone past the second option that you suggested, the administrative? If you need recounting, the timelines are clear. It must be immediate at the polling center, polling station.
Right.
If there has to be recollation, it must be within the center, correct? Then, if you have gone through all this, and now we are seeing a gazette of the results.
Contrary to what many people have thought of gazetting over the years, I do not share the same interpretation of a gazette. A gazette notification is an official notification of government, which by extension includes the affiliates of government, including the EC as a state entity. A gazette notification is merely a notification, official notification. A gazette notification can therefore be reversed either by the entity which issued the gazette itself, even if it goes through Parliament, or by a court. So a gazette, even though I must admit, it's a rare step, it hardly ever happens that a gazette notification be issued and then you have a notification indicating that either the previous issuance has been suspended or has been revoked. It hardly ever happens. But from a pure administrative law perspective, a gazette notification is not a judicial decision with the impressions of irrevocability unless an appeal. No, you don't have that effect. But again, by practice, because it hardly ever happens, it seems to have acquired the status of a certain sanctimonious process by which many people think that once it's issued, that's it. So you're right, particularly in terms of the process. The Supreme Court's decision and the general practice since 2012 has been in one direction, i.e., elections are won or lost at the polling station. And particularly in respect of the recounting and recollation, if you don't get it done at the polling station, that's it. Practically speaking, I can understand why we have that process. And the reason is because the transition between the polling station and any collation center has had all kinds of things happening since 1992. To avoid that, when elections happen right in the heat of things and you have everybody standing there and the counting is done there, and there are certifications per signature, nothing should change. So that decision and that process, I fully understand and I fully endorse, and that explains why, as your previous speaker earlier mentioned, your previous guest earlier mentioned, I have a difficulty with understanding why this simple arithmetic appears to be a challenge for us.
Are you saying that the administrative process that has the possibility of reversing a situation is available and therefore the NDC can be pursuing same? Because, like you note, the law says gazette notification is only a prima facie notice that this thing is the correct thing. However, it is rebuttable. If you have the evidence to show that the thing was wrong, then it will be wrong. But question is, where will you produce that evidence to change it? Is it the EC or in the court? And like you said, transmitting the results from polling station to collation, all sorts of things can happen. I have blown the whistle on 2 pickup loads of foreign ballots at Asawase in a by-election, and the police impounded them when they were going for collation. So these were not ballots cast at the polling station, but that were being attempted to be smuggled into the collation center for whatever purpose. I don't know. So are you saying they still can be pursuing the process of a petition to the EC rather than to a court?
I am not in a position to advise the NDC, and there's no rather than situation. As I mentioned, these three can be pursued simultaneously. At the moment, there's a court order, as I understand, against the NDC from demonstrating. So it appears the demonstration component, which is the political component, has been stymied. So that option is out. But the other two, the EC still can be petitioned. And the EC, as I indicated, by practice, it hardly ever happens that when you have a Gazette notification issued, it can be reversed. It can, but in practice, it hardly ever happens. Okay. But the EC can still be petitioned. And I believe that where there's a preponderance of evidence, where the evidence is overwhelming and too palpable, I believe that a body like the EC will not close its eyes into looking into that. But invariably, yes, the courts are the final avenues for this. I.e., the Constitution itself recognizes that at the end of it all, where there are contestations and where disputations about electoral results, the parties are allowed finally to come before a court and to present evidence. Of course, the difference between a court and the EC may be the question of the weigh-in and the weighting that will be placed on a particular evidence presented. But at the end of the day, yes, both the EC itself, the EC is not functus officio yet. I've heard people say it's functus officio. In other words, the EC cannot, the EC is not functus officio yet. Its work is not done yet. Okay. It is still very much in it. And I think the commissioner indicated that clearly, that she is happy to receive the petition, she will look at it, and she will respond appropriately. The EC is still very much a referee in all this, and it can do something about it. So it's not out, people can't disable it yet. Yes.
You cannot project that the EC's reply will be but one. I'm sorry, we have gone past this stage. We are unable to do anything about
How
the
did
results.
You come to that
if you
projection?
are aggrieved, please go to court.
How did you come to that projection?
I'm asking. You don't think that's the reply the EC will give?
No, I don't. It's look, first of all, things are a bit too delicate at this stage to prejudge things. Because otherwise, then what you do is that a lot of people may wait in the lines to say, we told you so. So I think at this stage, I would still want to say good judgment and good sense will prevail if things are palpable. As your guest indicated, if the signatures at the polling station, the primary source document, as you referred to.
Pink sheets.
The pink sheets. If everyone has signed the pink sheet, and all these are put together, and everybody's signature is there, no party has disputed any pink sheet, and we do the calculation. I'm terrible in mathematics, but I think this one, X plus Y plus Z plus, it should be very simple, frankly, to get this done.
Okay.
And so I believe that if the parties really come to the table, and it's not just the NDC, the NPP also has issues with some polling stations, the NDC has issues with polling stations. Once those are clarified and the various computations are done, we'll put them together and we'll calculate. I don't see how we should have any deaths.
Do you think, what will be the posture of the NPP if the Electoral Commission decided to allow such a thing because of the high stakes? Because if the review internal will result in the NDC candidate now being declared as the winner, then it means the NPP doesn't have the opportunity to form the majority in Parliament with the independent joining them. It means they will lose the opportunity of naming the Speaker of Parliament. They are going to lose the opportunity of a majority leader and the leadership, the deputy speakers, and the leadership of each of the committees in Parliament, except one or two, must be led by the party with the majority. Do you appreciate that?
Okay, so it's easy sometimes to accuse academics of living in an ivory tower and not knowing realities. But there's a reason sometimes we live in an ivory tower, so that we are dispassionate. Look, in 2012, I think 10 happened in 2012, right?
Yeah.
Yeah, it's 2012. In 2012, the whole Electoral Commission descended on 10. And it was funny, but the whole country literally descended on 10. I think, beautifully, the elections have been conducted and it's all done. But the whole EC can decide to descend, not necessarily go there, but descend itself administratively on Techiman. It's not palatable to any party, especially the NPP, who are officially winning. They've won officially. it's not palatable if you have to open up. If I'm the one and I want officially you have to open up, I'm clearly not going to be happy about it.
And in a situation where just that single seat
can make a difference,
changes the entire
it's not palatable.
dynamics.
It's not palatable for the NPP, and it's delicate. A lot of things are at stake, so I can understand that. But I think if you have a situation, that's what I'm saying, that if the evidence is palpable, they presented a petition. So I haven't seen the detail.
Okay.
But if the recipient, which is the commissioner of the EC, thinks that there's a serious issue to look at, I think in the best interest of closing that for good, the commission may just want to look at it.
McMahon will speak to whether there is any issue to look at at this point. But my last question to you will be to try and educate some of our viewers and listeners. The NDC's major problem and the reason they aren't giving in on this fight has been identified. The very first day Parliament sits, the next Parliament, the 8th Parliament sits, the party that is the NPP that has 137, just like the NDC 137, already has the Formula Independent Party member, who is an NPP guy they expelled, declaring that he will sit or he will vote with them, which will make them get an extra vote. You need only simple majority to pick a speaker. But if you want to remove the speaker, you need 3/4 of all the members. Now, educate us. If it happened that in the course of the life of the Parliament, NDC went to court and won the seat, then their numbers changed. Is the court able, in declaring that the speaker be removed, the leadership of the Parliament, everybody change, the NDC should reconstitute, the Parliament should reconstitute itself? And that is the bigger fear, because if they won the seat through an election petition in the High Court, you need 3/4 to remove the speaker. How are they going to do that? Because they need votes from NPP to do that.
Well, first of all, it's a question of deciding whether you're removing the speaker, and that's why I have to be honest. We're in a bit of uncharted territory. Parliament is not constituted without a speaker. So even to constitute Parliament and then to have a subsequent decision of the court impugning the previous constitution, i.e. because there was a speaker who obviously now has been deemed not to have been the speaker because the majority wasn't the majority then and the minority, all the permutations you put together, then you would have created a situation in which even Parliament itself may not have been constituted on the date it was constituted at the time. It could have all kinds of complications and all kinds of difficult permutations. But the thing about law is this, in principle, law doesn't accept a vacuum, as you know. So the principle of the idea of there being nothing at a point in time, the law doesn't accept that. So if Parliament was constituted and subsequently all these issues come up, the law will still admit that whatever may have happened then is valid, even though at the time it was done, all these things have turned out not to be the case subsequently. In terms of, therefore, removal, the question may not, strictly speaking, and again, I'm not a court here, but I'm just, since your question about education, the court, I suspect, will use, the purposive approach on some of these things. And the focus, therefore, will not necessarily be on technicalities. So that
you have a majority.
So the issue of,
you have a majority which you secured subsequently, and yet you can't, in fact, form the majority in Parliament.
Right.
You can't determine who is the speaker. You can't have majority leader. Nothing.
It may not be deemed, therefore, as a question of removal. The Supreme Court decided in the case of, in the case involving Aban, the late Justice Aban's appointment as Chief Justice, and the Supreme Court indicated that, in fact, the application that was brought to the Supreme Court was wrongly brought, and that we should have gone through the process of removing the Chief Justice. And I have argued against that case over the years that it's not a question of removal, because the challenge against Justice Aban then was not on whether he should be removed as Chief Justice, but on whether he was even the proper Chief Justice in the first place. And so if you are not a proper Chief Justice, then you don't even fit the bill of being removed under the removal clause, because the removal clause is reserved for Chief Justices. The same principle, I think, should apply here, i.e., if you have someone who's appointed Speaker and subsequently there are issues about that, and the court determines that indeed the process shouldn't have been in the first place, then it's not an issue of removing a Speaker, it's an issue really of just correcting the process. So the requirement, the constitutional number requirement, will not necessarily come into play. But again, I have to indicate we're in uncharted territory.
Right. So from your preliminary, view of the matter as to the Speaker and what may or may not happen subsequently, do you appreciate why the NDC will fight this with with everything in them, so that it doesn't happen, and then later, if they are successful, and the NPP will also think the same way, because they say they have as many as 4-5 seats that they are going to challenge. So if the NDC today, EC through a review, got the NDC to form majority, and then they set up Speaker, everything, they took up all the leadership in the House, and then the NPP subsequently won. Then they formed the majority, and yet they cannot remove the Speaker and they cannot change how Parliament has been constituted. I suppose this may tell the stakes involved at this moment in Parliament. Now, is there really anything to resolve in Techiman South? I know your answer is an emphatic no. Explain.
I think that we have an election, and various speakers today have stated the process, the pre-election, the election, and post-election. The pre-election, you yourself admitted that there's nothing wrong with the voters' register. And it is the register that is used in casting, in determining who is qualified to cast the vote. The votes have been...
you referred to Tain as 2012, it's 2008. Yes. Yeah, 2008, correct.
Yeah, right, 2008.
Yeah, please go ahead. Sorry for my interruption.
So the pre-election era is going on well, which you yourself have admitted, despite various insults and misunderstandings that went on during the registration exercise. We are now in the post-election era. In all electoral systems, the independence of the Electoral Commission can never be doubted. If you want to doubt that, I think the proper place to do that, after exhausting various internal mechanisms, and as you also rightly said again, timelines forbidding you have to go to the court. We cannot sit 2 weeks after an election to be still collating results of 300 polling stations. Are we so mathematically deficient that we cannot add 300 polling stations with a total of about, let's say, 150,000 numbers? And as we used to say, numbers don't lie. 2 + 2 is always 4. Whatever you do is 4. The numbers don't lie. So if we've gone through the electoral process, we've got into the post-election, some people are calling for audit. We always have post-election audit, which will then lend itself to reforms that needs to be done, be they administrative, legal, or constitutional, depending on the nature of the audit. So, for me, where we are now, we've crossed the carpet. And let me say emphatically, I have heard some people saying that Farijan in I think this same 2008.
Yes, 2008.
MPP went to him with some errors.
Sense, yeah.
It is absolutely not true, because I was there. I'm a practitioner. He's an academician. I'm a practitioner. I was there in this, in quote, strong room. And I led the MPP team that submitted the letter to him, Dr. Farijan, that we have some misgivings about the results, so he should wait. Give us 3 or 4 hours. He didn't. What he told us was that if we have any evidence, we must come to court. Who tells you that Afrejan examined our documents and then found nothing? It's not true.
We are told that the declaration was delayed because of your petition.
It's not true.
And Peace Council was involved in trying to resolve that matter.
Last 2 weeks declaration, I was there. Many other people were there. I was sitting very close to the ambassador from the European Union. So if all these people are there, they weren't there because MPP was coming to present a petition. They were there because the declaration was going to be made, to be effected, and they needed to be there, as I was saying. And we were asking him to put a halt to it for a few hours, which he didn't. There is also some errors being peddled about, as if this is the first time the Ghana police have stopped or has obtained a court order to stop people from going on demonstration. I'm telling you, if you go on City FM online, 28th September 2015, the police secured an injunction to prevent pro-opposition, which is MPP, pressure group, Let My Vote Count, from picketing at the presence of the Electoral Commission. That was in 2015. So if today they have gotten the same court order to prevent other demonstrators from going on, is it new? It's not. And it's not the first time. So the people should not make it look as if this is the first time the police is preventing demonstrators from.
I don't think anybody.
Thirdly,
that. No, let's settle that quickly. In 2015, we all roundly criticized the conduct of the police. I remember at the time, the NDC people were saying I was the lawyer for the Let My Vote Count people. They didn't know I was not. Now, we remember how Gabi and the rest were whipped and people suffered. Some guy lost an eye in the process. They went to court.
He has died.
Yes, they went to court. Now, what we have been referring to is that when they went to court, a justice of the Court of Appeal, Justice Dennis Ajay, sat on the matter and reversed the police's earlier action and said they are not allowed to go to even the lower court and to go on the blind side of the demonstrators. The question we are asking today is, the law says once they bring you their notice and they give you the routes they are going to use, the venue, everything, you must get back to them and tell them of your disapproval. If you want them to rearrange and so on, get back to them. And they must get back to you in writing within 48 hours. It is after that, if the organizers disagree with you, then you go to the court to try to stop them. Did this happen? I think that's a legitimate question. Please, you can go on.
Then also, NDC fear to go to court because there is history of Rebecca Adote, George Amo versus Rebecca Adote, where George Amo contested the win, the parliamentary seat, Ayawa Subugon, in the
2006, is it?
No, we didn't have elections in 2000.
I said 2006.
The bottom line is
16.
The courts delayed the processes and the judgment came out after the end of that parliament.
Yeah, the life of the parliament.
So they fear that something similar may happen to them. So they think that they can get a shortcut. But there's no shortcut when the dates, the times of action, like the results, you cannot finish an election which is supposed to end at 5 p.m. and there are no people in the queue, and you say you won't count. You have to count. When you finish counting and you fill out the statement of declaration of results and they are signed or not, because not signing does not invalidate it, you have to take it to the collation center. And in the case of Techima, when we called a press conference, showed a video of what transpired at the collation center. You need a serene atmosphere to do this kind of arithmetic we are talking about. But the atmosphere that was shown on the video is nothing and is shameful to the electoral process in this country. That people will deliberately invite the public, particularly NDC supporters, that NPP is going to steal the elections. So they should mass up at the various collation centers. It's not only in Techiman. They did so in Esikado Kitan. They did so in Dansuma. What's the name of the constituency? Esla's constituency. They did so in
West.
Seshuyoso. So it was a deliberate plan, calculated that where they are going to lose, then they must make the collation exercise messy and chaotic. And that's what happened. That's what happened. The whole place was turned into a chaotic situation. Are you going to be able to add numbers in such a situation? But if you look at the video, the returning officer did well, calculating, adding up the numbers, and when he had the microphone and did the announcement, somebody who is an NDC supporter came and took it away from him, and the police or the military had to chase him and bring the microphone back. What kind of life is this?
So the pictures you are watching, okay, the NDC's candidate was in the picture, and
he is allowed by the law, so he could be there.
He was in the picture, and you saw the Electoral Commission, that's the returning officer, right? That would be the returning officer.
I don't know.
Collation center will be a returning officer.
Yes.
Right. Trying to declare the results. And as he took the megaphone and tried to do it, somebody tried to pull it from him. And then you see the military or the security try to stop that situation. So from the footage, it appears...
Look at that.
It appears on the face of the footage that there was in fact a declaration. However, the NDC is insisting that that declaration did not emanate from a collation, because there must be a collation. The collation is that you have all the polling station results brought together.
Yes, as in the law.
And that did not happen. That's what they are challenging right now. And they say there could not have been a collation. In fact, when Jean Mensah was declaring the presidential results on the 9th of December, she said that the results were exclusive of Techiman South because there were problems and contest with the results there.
Fine. I don't take
presidential results. Presidential results.
It's presidential results.
Can I finish?
Okay, please.
Presidential results. But what do we know as a matter of fact? Was it the parliamentary results that was in contest, or it was the presidential results that was in contest? So that's the NDC candidates. You see that being held right in there. And the EC gentleman...
That's the declaration he's holding.
Trying to make the declaration. Yes, that's the NDC guy. Candidates you see in your shot. Right. So the point is, you say a declaration was made. The NDC insists that even if there was any such thing, that was unlawful, and therefore they don't even admit that it exists. Because as of today, they are asking, where is the coalition sheet? Do you have one?
First, let me correct you. Jean Mensah says he did not add Techiman. What has that got to do with parliamentary elections? Because under the law, returning officers declare parliamentary elections, and it's final.
That's right.
So why are you bringing that on the issue of presidential declaration by Jean Mensah? You just want to bastardize Jean Mensah.
Okay,
no,
so wait.
Please.
So wait. No.
Even then, all the figures, you gave it to Mahama. So what is the net effect?
Right, fine. Forget about that. Now, here's the point. At the time, she was saying that she could not declare the results for that area. She could not add the results for that area because there was a contest.
For presidential.
Yes. because there was a contest, had the results for Techiman South been declared, as you say?
The results had been declared.
On the 9th?
You saw it.
Right, on the 9th, on the 9th. Now, so step by step.
Yes.
What do we know in fact? Is it the presidential results that were in contest or the parliamentary results for Techiman South that have been under contestation?
Well, from Jim Mensah's point of view, both. That's why he didn't
both
initially. That's why, because she cannot declare parliamentary results.
Obviously.
So obviously she was speaking for presidential. And she says, even if we give all the total number of registered voters to John Mahama, he still loses the presidential election. That's what he said. So you bring this in to do what? What is your aim of bringing that?
My job here is to ask the questions. So,
but I think
you are explaining.
Relevant.
No, you are explaining. It's relevant, very relevant.
What is the relevance?
It's very. You may deem it's not relevant, but I think it's very relevant.
All right.
Now the question I ask: do you have the collation sheet? The NDC says, where is it? Because without that, you can't make a declaration.
Let me tell you that if NDC wants to see collation, they made a press conference and came out with an Excel sheet and bundled some red sheets, whether they are pink sheets or what. That these are all our pink sheets, as a lawyer rightly said, that you need a primary document. If they have that, let them go to court. Why are they going to worry Electoral Commission? We have ours, and we will meet them in court.
You dispute their figures. And you dispute their claims.
Yes,
you dispute their claims.
Yes.
So you held
You
held the press conference.
Yes.
Why don't you want to finish the subject matter by showing us your collation sheet? Which is the bone of contention.
I opened myself to the public and the media, if anybody had asked that question. Because at the press conference, I invited our executives from Techiman to be with me. They came. In fact, the IT coordinator, he showed all the tapes, the video and everything. Not me. I was not there. So it's a collective teamwork that we did. So something, at the press conference, everybody had the opportunity to ask questions. And I had my team, my parliamentary candidate, his team of executives and election officials from MPP in Techiman. They would have answered all this.
Since you wanted to terminate that discussion and put them to shame that they were wrong, and the central issue is that they say there couldn't have been a declaration because there's no collation. Why didn't you show that piece of evidence, if you have it?
Which piece of evidence?
The collation.
The collation, what is the source of collation? The source of collation is the pink sheet.
Correct.
It is added together and you get the summary or the totals. And we have all. We showed it. We opened a few to them and we gave the totals. So if you can have the totals, what's that? I mean, why do you make the summary more important than the makeup of the summary? Why? Why are you making the summary? And you want to say the whole is greater than the parts. If to me, it's the parts. If you don't have the parts, how are you going to get the whole? Huh?
There's a form.
That's a form.
That indicates that there has been collation.
That is the total.
Do you have that form?
I cannot say.
The NDC say they don't have that, and that is.
Well, but even if you don't have that, I'm saying the parts that make up that form is available. So what's the problem? You think if you go to any other place, this is collation form. Okay, I don't have it, but I have the makeup. 300 and something police stations, including the security services, is there one by one. What's the difference?
What will the returning officer use to do the declaration? Is it not the collation form? They said
he did that, and you see that Meli, the chaotic situation there. Somebody even took the paper. He was holding the paper and making the announcement. That was the collation sheet.
I guess if I can just, not to interfere, but if you look at the structure of things, if you have the collation result and you don't have the
summary,
you have a problem. But if you have the pink sheets and you don't have the collation result, you don't have a problem.
No.
In other words, it is the pink sheets, the individual pink sheets, that will result in the collation.
That generates.
So if the
But the
collation,
law, CI 127, names a form on which the collation ought to be on and duly endorsed and signed, which is what has to be announced. The NDC says that is not in existence. If the NPP has a dispute on that question, the way to settle that debate is to show that document. They haven't shown it.
no, absolutely. I mean, I
They haven't
guess
shown it. That's the form he's showing to you.
exactly. So I guess again, these are forms. They are not. So the lawyers will distinguish between forms and substance.
This is
They are
not form
not-
and substance.
In
The law says you need to fill
No,
this
I
form.
understand that. What I'm saying is, assuming, for example, these were not done,
Right.
they will not nullify the elections. The process can be completed by making sure that this is then done.
There can be a declaration without a collation on the collation form or sheet. Collation form, that's what it's called. That's what you're saying?
No. What I'm saying is, assuming that that process was not completed, that process can be completed. However, the opposite is not possible, i.e., assuming that the individual results are not available, that cannot be possible. Then it means the whole process would never have existed in the first place. And that's, I just want to clarify that point. I think that's the point he was trying to make.
That's right.
That the component part, i.e., the individual results, and that's the point.
That's the point.
Also made by your earlier speaker. You know, if you have the individual results, that's
300 and I think.
so I think if the parties can agree, the most important thing, if the parties can really agree, and the EC, of course, can really agree on that individually declared results at the polling station, I think they're putting together, including this, i.e., if the process truly was not gone through.
Okay.
But I'm just saying the opposite cannot be accepted, i.e., you have the collated results, but then you don't have the individual results. That means there's nothing. If you have.
So Regulation 43 of the CI you are holding, Dr. Bochi, the Regulation 43(1), specifically 43(1)(e) and F, if we may read them to finish up on this part of the discussion. 43 is headed Declaration and Publication of Parliamentary Election Results. And 43(1) says, subject to Regulation 42, immediately after the results of the poll for all the polling stations in the constituency of the returning officer have been given to the returning officer, the returning officer shall, in the presence of the candidates or the representatives of the candidate, or not more than 2 counting agents appointed by each candidate. F, give each candidate or the representative or counting agent of a candidate a completed and signed copy of the parliamentary election results collation form as set out in Form 1C of the schedule and the parliamentary election results summary sheet as set out in Form 1D of the schedule. Then that's F. The final part to read, I should have read E before I come to F. E says, request the candidates or the representatives or counting agents of the candidates to, together with the returning officer, sign the parliamentary election results collation form as set out in whatever it is. And then when everything is done, post a copy at the constituency collation center. So, reading the law, if that is only if, that nobody can show this form, do you say that still it's proper?
Samson, what happened in the video? The collation form were available.
Okay.
I am told reliably that the NDC were invited to come and pick theirs. One paper of the NDC was invited by the EC in Techiman to come and pick their collation summary and form. So if he did not go, MPP, that's not our business. That's not our duty.
Okay.
We have a duty to ensure that we get our documentation intact. And that's why we posted polling agents, well-trained, committed and loyal, to deliver for us.
This form should be displayed. It should be posted on the walls of the place.
Everywhere in the country.
So since there is not one there, since so far you have not shown us a copy, the NDC insists it didn't happen. How do we end this discussion?
I'm saying that they were invited to come and pick their copy.
You have your copy.
I'm told we have a copy.
Okay.
This is why I made a point.
So McMenu is saying he's told they have a copy.
Right.
He didn't show a copy to terminate this discussion. And as we speak today, he can't show us a copy to terminate the discussion.
Okay, we
oh, but I don't have any. I don't have a single polling station result here. But I did show it when I invited all of you to the...
No, I'm not sure you did. If you did,
at the press
discussion would have ended.
At the press conference?
Yes.
I did.
Okay. Please look for Mark Menu's press conference and look for the portion where he says he showed the collation.
I didn't say I showed. I said I showed pink sheets. That is polling station results. That's what I showed.
Okay. Yeah. I am talking about the collation form. Kwame, quickly, what do you say about this? Quickly. I hear you want to say something.
I find this all very interesting, especially Chairman Mark Menu's assertion. I mean, when I listen to the part of the law you read, it says that that collation form should be posted at the collation center post the declaration. I take Mr. Mark Menu's view that there was so much chaos that probably on the day it couldn't be done. We are weeks away from the election. What has stopped the Electoral Commission from actually doing what is stated in the law by just pasting it there, which is shall. It is not something that they can or cannot do. What is stopping? You see, sometimes I look at these nitty-gritty and I say, we just like recklessness. Unfortunately, sometimes we need to call a spade a spade.
Or Kwame, you mean that if it is not posting it, in the heat of all of this, it should post it to all of us, should post it to the public?
Or put it on their website, because the law says shall. Their website is a place where they can put this as well, in lieu of putting it at that center.
Okay.
Because, what do you call it? There was chaos there.
All right.
And we know that some courts have been clear that you can even serve people's sermons by WhatsApp. So what stops them from just putting it down and terminating this conversation?
All right.
But they were invited
recklessness
to come and pick the
sometimes I cringe when I see the level of recklessness we try to go into and then get into all this gymnastics.
Okay, Kwame, hold on there. Let me bring
to move past this.
Thank you. Let me bring the NDC in briefly on this subject matter. And the MP and MP re-elected for North Dine, Roxanne Nelson Dafiamapo, South Dine, who is also part of their legal team, joins us on the phone. Thank you, Roxanne, for your time.
Thank you very much, and Merry Christmas to you and your viewers.
Roxanne, the collation form, you insist you don't have it. Up to this point, you still don't have it. Hello, Roxanne?
Yes, Samson.
You insist you don't have the collation sheet or form. You still don't have it?
It's not even a matter of not having it. Not having it suggests that it was actually created. It wasn't done. Now, I heard Mr. McMahon say we were invited. Something, you read the law. The law is very clear. This is a document, the creation of which takes participation from other people. It's not a document that the EC can create on its own and just give copies to you. The political participants are supposed to participate in the generation of the document. That is why at the end of the day, it said that after you have signed, your agent or your representative or your council agent is given a copy. So for him to say that we were invited to come for a copy, it's a complete concussion. It was not generated at all. That is why in our petition to EC, we are demanding that is a legal requirement. In fact, it is a requirement that must be specified before any resource is declared.
All right, so the question I was going to ask you, you are attempting to answer, that you cannot have a declaration without the coalition form. Is that what you're saying?
That is not what we are saying. That's what the law says. So we are simply asking EC to abide by what the law requires.
In the case where a declaration has happened, presently assuming in the absence of a coalition sheet or form, how do you resolve that issue?
Then it's a nullity. The legal requirements have not been complied with. The law has been breached. Because you see, the coalition must be contained on a statutory form, which is contained in the schedule to the law. We can't do this outside any other format. It has to be, whatever results declaration that has been done must be in accordance with as laid down in CI 127. It's as simple as that.
Who will say it's a nullity and it carries a final, it carries finality? Who will say that? Is it the court or not?
To do that.
It will take a court to do that.
It will take a court of law to do that.
Okay, so
somebody has to complain that the law has not been complied with, and that is what the NDC is doing.
Right. So are you going to court?
Yes, we'll go to court. We made that clear.
When are you doing that?
Certainly by Wednesday. Or by Wednesday, all these matters will be placed before court.
Okay. Wednesday appears to be the deadline for the filing of a presidential petition. How about the presidential, which you say is fictionalized and flawed? Are you suing as well?
We are suing. So much work has been done to tidying up the relevant evidence. So we are suing.
Interesting. So therefore, you will not pursue what you are pursuing with the EC any longer?
It's an alternative open to us. The whole process is mainly administrative. If the EC can put its house in order, why do I have to bring in a judicial arbitral body to look into it? If the EC will be willing to comply with the law, that will end the matter. It is not about declaring the seat in our favor. That's not what we are saying. We are saying that comply with the law. If we comply with the law and we emerge victorious, that is fine. But you do not comply with the law and announce another candidate as the victor. No.
What's your opinion, legal opinion, on what happens if it does happen that you are able to overturn the verdict of Techiman South after Parliament has constituted its leadership? What happens to the speaker who would have been chosen by the NPP, literally, and the other leaders? Now,
pursuant to orders 8 to 13 of our standing orders, as we do have now, the election of the speaker is subject to a nomination, which can be done by any political party. But the convention has been that the majority party normally will carry the day. The nominee of the majority party will carry the day. Right. So the effect of the scenario you faced will be that now will require a 2/3 majority of the House in order to torpedo more higher. The standard there is more higher than the simplest of margins in this case.
You said 2/3. A lot of people have been saying 2/3, but if you read the Constitution, it's actually 3/4.
Apologies. It's actually 3/4. As contained, the standing order is a direct borrowing from the constitutional provision. It's a 2/3, so it's extremely higher.
Right.
It's a threshold very, very much higher than it is playing out now.
Yes, that's Article 95 95 2D. How will you be able to scale that hurdle in case you won in a court? Because you will need MPP to support you to remove a speaker that they would have installed.
Yes, and that makes it that is possible, but it's not plausible. It is possible to get MPP to vote alongside you in order to remove a speaker that we think that ought not to have been done, given the situation. But it is not plausible. Politically, it won't happen.
Can that...
So it's the kind of scenario we see they want it to play out.
Can you secure that through a court?
No, I don't think any court can reverse that. I don't think any court can reverse that because these are constitutional requirements. If you get 3/4 of members of the House, then you can remove the speaker under circumstances that we speak of. You will see that under that provision, it gives you the scenario that in order to remove somebody who has been installed as the speaker, you need 3/4, and that's 75% of 275 members.
So in the circumstances of MPP having 137, NDC having 137, are you guys trying to reach any compromise at all as to the leadership, starting with the speaker?
Strangely, I have not picked up any such signal. And you will see that if indeed that were happening, public comments of our brothers would have been one of conciliation and all that. But we don't gather that from their public utterances.
Each party wants all the spoils.
Yes, and they still speak in a standoffish manner, in a condescending tone to the NDC. So clearly, these are not people who are looking for consensus voting at all.
So you guys are not taking a cue from the president. The president said what the people have done is send a signal that Parliament must work together. The two parties must work together.
I suppose that after the president spoke, the Minister of Information came to amplify his view. And you saw the tone of the Minister of Information on the night. I now further refer to other public comments of other senior members, including the General Secretary of the NPP, when he held his press conference about a week ago. These are very serious matters, and in the manner that they put the issues out, clearly suggests to me and a lot of my colleagues, and indeed the NDC, that these are not people who are looking for working together to advancing the cause of the nation.
It has to be the two parties. So I think you should not be pointing your fingers at the other party only. Are you ready? Are you ready and willing to propose, or are you amenable to, in fact, actually initiating a discussion to present a speaker who both parties will accept, so that if anything happens later, supposing the MPP gets an absolute majority, so to speak, because they are seeking to overturn as many as 5 of the seats, you are also seeking to overturn as many as 4 or so. Are you ready to, go the path I'm suggesting to you right now? Are there any names you are looking at?
Sam, I am. You are asking the NDC to make the initiative. Why should it be the NDC? It is the person who has been declared, who will be sworn in, who should be making the overture. And I shouldn't be the one making overtures towards him.
But the NDC wants to take control of Parliament.
In any case, if you understand the workings of Parliament, let no government or let no party be comfortable with the numerical arrangements we have now. Even with 106, they had real difficulties. A lot of the issues have had to be done on consensus basis. So I would be shocked if anybody will not be so concerned about the numerical arrangement of the 8 parliaments we have.
Okay. Roxanne, maybe a final question on that one. Can the NDC initiate this? Can't you look around? Look at people that the NPP is comfortable with, the NDC is comfortable with, within even people who have had things to do with your own party, so that you begin a process this way, rather than the current, animosity, the trade of, as it were, abuse that is going on, and the fight, which doesn't benefit anybody.
Sam, it's a good question you are asking. But here is the case. I am the one complaining about. Hello?
I'm listening.
Here's the case. I'm the one complaining about the outcome of the declared result. And I'm taking steps as required in Article 64 to go to court. So I am the bitter fellow here. I am the one that somebody should be expressing olive branches to. And that is the way it is done in society. If anybody wants to invent the practice and the convention and the custom, I will be scandalized. I am the bitter fellow. I'm the one crying. I'm the one saying that I have been cheated.
Roxanne, you are a lawyer.
Yes.
And you have been in practice. I think even having been in Parliament, I think I've seen you in court a couple of times.
Yes.
Is it always the case that it is the defendant who must initiate the process? Are there not times where you, the plaintiff, you, the one who has gone to court, is the one who is talking to the other party and say, can we sit down? We can resolve this on our own. Even though I tried, you didn't agree with me, and that is why I came to court. But now that we are all in court, can we try it again? You don't think the NDC can mute this idea?
It's a beautiful analogy you give it. But the plaintiff does that if it thinks that it is proceeding to court on wobbly ground. On wobbly ground. And we are on terra firma in this matter. And so, in respect of making consensus building, in respect of selection of speakers, as well as committee chairman and vice chairman and ranking members, I insist that the overtures in this matter has to come from the government.
I see. Hold on. Let's hear from Kofi Abochi on this.
The question of compromise candidates?
Yes.
I think it's probably the most brilliant suggestion you've given yet. I think that Parliament, the President hit the nail on the head when he spoke in his victory speech. He hit the nail on the head when he indicated that the people of Ghana have spoken to Parliament and indicated that members of Parliament and Parliament as a body must begin working together. I think that, as indicated, it's a loss for both sides. The NDC have made gains, but they still haven't, even if they win some of the seats that they're contesting, it's not as they were when they were in the majority some time ago. The NPP has...
That's the NPP, you mean?
No, that's the NDC. The NDC had majority some time ago in Ghana.
That's right.
I'm saying for the days when they had majority, they did not have... So even if they gain the seats they're fighting for now, it will still not be like the days when they had majority. The NPP had a stupendous majority, and now they're struggling to literally just have 1 or 2 people ahead. And that's... So both parties
and
have
in their case, too, whatever they do, they will not have what is comfortable.
Correct. So both parties have lost significantly. I expect, and giving you a suggestion, that this is the time for some back-channeling conversation. Unfortunately, because of all the disputations and confusion going on, it doesn't appear as if the parties are ready to sit yet. But I think that as and when the dust settles, there must be some back-channel, conversation for a compromised candidate to be suggested. And indeed, Parliament must begin really working with a bipartisan focus. Let's be honest. The only institution that, frankly, has still not been able to assume its proper constitutional roles since 1992 to today is Parliament. And parliamentarians will argue that there's a lot to do with the public doesn't see, etc. All well and good. But in terms of executive accountability, the one that is visible on the screens that we all see, since 1992, Parliament has yet to still perform that function. And so in this respect, this nail-biting, neck-to-neck contest between the parties in Parliament presents an opportunity for Parliament to start working as a corporate entity in its relationship with the executive. And in addition to that, particularly for the selection of the Speaker, because of what may potentially happen, who knows, because of all the court's prospects, both between the MPP. The MPP too are going to court, I'm told.
Yes, they are going to court on a number
on some
of
things. Right. So because of all the permutations that may come out, it helps that any Speaker who's selected would not need a contest. And I think the best option at this stage is probably to look at some compromised candidates that the two parties may. But
the breaking news is that the NDC, as Roxanne has confirmed right here, announced, firmly that they are going to court Wednesday, which is the final day that if they do not go to court, the presidential, they cannot challenge anymore. He says they are going to court on the presidential, they are going to court on Techiman. Of course, then the other ones too, they may do so. Does it compromise their situation if they initiated the process? Who should be initiated the process?
You mean the compromised?
That is right.
The Speaker.
That's just a political thing. Invariably, the president makes a suggestion, proposal. So I think the expectation is that because, and again, there may be an implicit suggestion. If you hear him carefully, there may be an implicit suggestion that even officially, the NDC is not really strongly contesting the presidential candidate. The presidential results. It appears from, because he said it should come from the one who has won, something like that. He used the word, I think sworn in. So my expectation is that invariably, it should normally come from the party who has the option to make that proposal. So normally it's political. It's a question of influence. I think the party which appears to be in the executive seat should be the one to initiate the process. And the process would have to begin by a conversation. It doesn't, I don't even expect that it will start by there being a candidate and then one being invited to consider. I will expect that it will start by actually some consultation, some unofficial meeting between the parties, back channel, quiet behind the scenes, to just engage themselves.
Yeah.
Because
we need to take a break. Professor Enin, do you want to say something briefly on this part of it? Professor Enin.
Relates to this famous coalition document. Does it exist? And if it does exist, where is it? And when can we see it? Two relates to our very first conversation around COVID. If you look at the pictures or the video that you've shown us, the COVID protocols were not respected, and I think that creates a very difficult condition and situation as the president appeals to the citizenry to continue. The third point, as we bandied all these issues back and forth, is where is Ghana in all this? It looks as if very narrow party individual interests are driving this sense of insecurity and locating this conversation within the context of the generality of the interest of the Ghanaian people, which is not there yet. The fourth issue is about where do we go from here? Now, the two parties, NPP and NDC, and tagging on to Kofi's good point about bipartisanship. I think we've reached a locked position in which both parties are incapable of moving beyond the narrow restrictions of their party interest. And because of the mistrust, we need an honest broker and an honest institution or a set of individuals to begin the process of back-channel conversations. Now, this is an issue that we raised already around the 8th, the 9th, and then the 10th, that from all the indications, the mistrust that started from Ayawaso, post-Ayawaso, short commission, the registration, have all hardened the positions of both parties. We now need a mediator to move the conversation over and beyond the narrow strictures that we are facing now, and we need to do it very quickly.
A mediator. Who are you thinking about?
Well, Samson, I think it would be improper for me to raise the set of possible individuals or institutions who can be part of this. This is something that I can share with you off record, precisely because we need to check the backgrounds of these institutions, the individuals that we want to suggest, and to say to what extent are they acceptable to both parties. Okay. Because immediately a mediator starts the process, and that process is beginning to move from a win-win situation. What that means in practice is that both parties will have to give and take. And the transition from where we are now to that win-win situation of giving and taking, let's not forget that both parties have hardliners who are not interested in peace.
All right. Okay, thank you. Thank you, Prof. Senin. Kwame, can I hear you in a minute on this?
I totally agree with Professor Senin. The fact of the matter is, even on this program, if you hear Chairman Mark Menu, if you hear the MP for Dai, it is clear that no one is moving. It's like what we call in chess stalemate. So we need people to force them to move, because Ghana is more important than any of the two political parties. If they cannot even agree on a declaration sheet being posted, I struggle to see how they can agree on a Mr. Speaker. So something else would have to happen.
Rhoda too wanted to say something. Rhoda, would you want to do that quickly? Mark will speak last on this, and then we take a break.
No, certainly. I think it's very much welcome the decision of the NDC to go to court, whether that has been because of the ban the police have secured on open protests and all of that. But I think it's a good move. And of course, earlier I made the point that it would be important if the Electoral Commission could supply just information to the public as a duty of accountability. If that is not coming, and then the NDC is going to court, hopefully the court will be able to step in, because we need to understand all of these things that have happened. If there was a declaration, if there was collation, the collation sheets, where are they? Because like we said, the law requires that these information are provided, even at the polling station level. We know that in some instances, some poll officials don't do this. Sometimes, for various reasons, maybe out of forgetfulness or whatever, but given all the contestations that have come about, it's essential that the Electoral Commission supplies us with this information. And if it's not coming, then the court should be an appropriate place for all of these matters to be addressed.
Thank you. Yes, Peter McQueen.
Yes, I think the MPP will welcome Mr. Dafiamapo's speech that they will be coming to court, and we will be prepared to meet them in court. In respect of the compromise speaker, I think he also said that even at the 106, 169, there have been various forms of compromises. So I expect that there should be some consultations, back-channel consultations between the leadership and the president to enable a compromise to be reached on who should be the speaker of the next parliament.
Okay. Very, very refreshing. Of course, for McMenu, I can say that this is his demeanor. To have the two parties represented, speaking in such a conciliatory manner, whilst they still agree that there are issues they can litigate in courts, that certainly is a good thing to do. Roxanne, what did you want to say on that?
Yes, I heard Sinyabuchi intimated that it appears the NDC is no longer pursuing the presidential fight. No, that's never our position. You know that you just don't get up and go to court. You must put your house in order before you go to court. And that's what we've been doing so far. So as for the court, we'll go. So no impressions at all that we are no longer interested in litigating the results of the presidential outcome. Are
you filing the petition on Monday or Wednesday?
Monday is a holiday. It's a statutory holiday.
Okay.
Yeah, so by Wednesday, you should hear of our filing.
All right.
Then are they still going to continue with the street protests?
Rhoda suggested that we appear not to agree on whether or not there was a collation at the Chiman. It wasn't done.
Okay, I think we are finished with that issue.
Yes, it wasn't done.
Right. So now the next question to you is,
yes,
since you have firmly decided, finished your preparation, and you are filing a petition in court between Tuesday, Wednesday, should your people still insist on hitting the streets across the country as they have been doing?
Why not? It's an alternative open to us. We can decide to pursue that as well as the court case. It's all a choice within the law. It's the requirement. Once we comply with the law, we can still go out there and stage a public protest.
What will you be saying at the public protest when you have a case in the courtroom asking the judges to reverse the verdict?
The public protest, something will be comment snippets of material that we have placed before the court. You know that is the placard that will speak loudly for us. But to stage a public protest whilst we are in court does not detract from the law at all. It's an alternative open to us. And as a party, if we decide to pursue it, no law distracts us from doing so. Once we do so in accordance with law, we are good to go.
I see. All right. I want to take a break here, and then we'll return to look at the year in retrospect. But yes, McMahon wants to say something.
Before you go.
Right.
Regulation CI 127.
Right.
Regulation 3.
Uh-huh.
Duties of a returning officer.
That's right.
Among others, he is supposed to assemble the results from the polling stations and publicly declare as elected in a parliamentary election the candidate who had the highest vote. Mm-hmm. So if he has assembled the result from the polling stations,
right,
and has declared the parliamentary elections, what will prevent him, if not the use of force, as we saw in the video, from doing the summary? I mean, obviously, these are part of his duties, and he was performing his duties under the CI.
Okay, so you are saying that he will have a defense or an explanation why he couldn't.
After that,
why he couldn't comply with Regulation 43.
That after that, they had to move the collation center to a different place, a serene place.
Okay.
And when they did it, they invited the NDC to come for their copy.
I see.
Yes.
Okay. So
these are his duties, and he was in action, performing his legally mandated duties.
All right.
And in this atmosphere, and in any case, many of the people there from the NDC were not supposed to be in that room legally.
Okay.
It's only the candidate and 2 agents.
All right. So let's have a final point on this, and then we take a break. Roxanne, we know that a group of citizens in the Guan area, we know that Professor Margaret Kweku, who was the parliamentary candidate for the NDC for Hohoi, there is a Simon Alan Opoku-Minta, John Kwame Obompe, Godfred Koku Kofi, and Felix Kwashi, nicely represented. One from Lolobi, one from Lekpe, one from Santro Kofi, and then another from Hohoi, are in the court saying that they were disenfranchised by not being allowed to vote in the parliamentary, and because of that, the Hohoi elections that led to Peter Amewu being declared the winner is unconstitutional. And then subsequently, led by Chachuchi Kata, they procured an interim injunction for 10 days, stopping Amewu from holding himself out or suggesting to anybody anywhere that he is the MP-elect. The EC2 is injuncted from doing so, and also from gazetting. We know that the gazetting has already happened. So what does this do? What's the effect?
Now, the effect is that the EC is supposed to do 3 things after declaration of results. The first one is the endorsement of the writ of election. then in the language of the law, it says immediately you have to gazette.
Mm-hmm.
Then the third thing that he is supposed to do in the chain of action is the notification of the clerk to Parliament of the details of the elected candidate. And so that is an action that the president's injunction would affect if he intends to do so within the coming days. And it's a very critical one. Indeed, it is that information that will enable the clerk to Parliament to take the necessary steps to make preparations for the swearing in of the respective MP elect.
So it is your expectation that when you assemble in Parliament after your last sitting on the 6th of January, that on the 7th, Amewu will not show up there?
It is my expectation that if the the effect of the ex parte motion and the other attendance of it, it will last for 10 days.
Yes, which elapses before the 7th.
Exactly. So it will be my expectation that the substantive motion or notice will be repeated.
It has been filed. It has been filed.
Very well, very well. Now, if the court finds favor with the argument, and now grants an interim injunction properly so called, then that will be the effect.
Okay, so, and it's also possible that before the 7th, Amewu can go to the court and vacate this interim injunction, right?
Yes, that's a matter for him to, and his lawyers to look at.
Okay, so if this injunction does not live beyond the 7th, up to the 7th, then it's not good enough, is it?
Well, not good enough for him, not good enough for the MPP, but you know that it will not be fatal because if you recall in 2012 or so, the Honorable Kennedy Ejapon was not in the Republic when swearing was done. But subsequently, he got sworn in. So we have precedent. These are not matters that are, for me, that are very fatal. Right? The regularization can always be done.
But your prayer is that the ex-party, as has been repeated, will be granted before the first sitting of Parliament, which is the 7th. But the date on the repeat application is on the 11th of January. That will be after. So, if nothing happens, it is not. If nothing happens, then it means the court will not hear the injunction itself before, the swearing in.
Yes, the dawn of the service.
Yes. So your expectation is that on the 7th, the MPP will not have the sufficient numbers to appoint a speaker?
Yes, because you see, the pendency of the motion, which is now on notice to all the parties in the matter, is injunctive enough. That is the principle that we've all come to. That is settled now.
Okay.
That's the principle. So
interesting.
What they can rather do is to apply for abridgment of time.
So that the case can be heard before the 7th.
Exactly. So that it can be heard on its merit before the 7th.
Okay. And then,
as a practitioner, that is what I would have done.
Okay. And then if you happen to lose it, then no consequence again. The MPP is assured of getting the formula and forming a majority to do the things they need to do. That is, if you guys don't agree on compromise. Then you don't compromise.
Your use of the word assurance, the formula MP can only vote in associated with the MPP. He cannot join the MPP.
Yes, of course. That's what I'm saying.
Yes, but you can't have the assurance like that.
He has already given it to.
No, you can give the assurance. But
also,
if I may make the point, the secret ballot system in Parliament, we are going to insist on it strictly. Every member will be in his place, and then the clerk will bring the paper to you, and then you vote. It will no longer be a situation where you walk to the middle
Interesting. So his expectation is that if they vote by secret ballot, even some MPP MPs may vote against.
That is the danger they face.
I see. Interesting. So let Abochi finish on this one, so we take our break now. On the injunction they have secured, interim, for 10 days, but which expires before the 7th. And then there's a repeat application, which is going to be moved or argued on the 11th. Do you find that they were seeking to stop the EC from gazetting Amewu? As we know, by the time the court was granting the injunction, the gazette had already happened. But there are two other orders of the injunction relief. That is that the EC shouldn't present him, and he himself shouldn't present himself. What do you see happening?
Well, as indicated, for practice purposes, the right thing to do is for Mr. Amewu's side, his lawyers, to apply for an abridgment of time for the matter to be heard before time. I think that's the most practical thing to do, and I'll be surprised if that's not done. If that is done, the court invariably would have to sit and decide the matter before then. So it's a straightforward matter. We'll know whether indeed Mr. Amewu's election has been confirmed by the courts, and that's it, or that the court has otherwise, upheld the arguments of the current application, which is seeking to basically undermine his election because of the fact that there are challenges to the credibility of the whole process, including people who have not had the opportunity of voting, particularly in certain areas. So I think the easiest way to do this is to hear the application before the 7th, to leave nothing in doubt.
You say I'm a lawyer, I shouldn't be asking the question I'm about to ask, but sometimes,
for the public,
sometimes you guys don't do that to me. I don't sit here as a lawyer. I sit here to reflect the views of the people who watch the show. Some say it is an impossibility, given the stakes, that his presence, his absence in Parliament will create such a huge problem. You can't expect that he will in fact be injuncted.
A judge doing his work, and I expect that a judge will do his work. A judge doing his work is not alive to these pressures. A judge doing his work, strictly speaking, looks at the law. And let's face it, in 2012, this country was at a certain knife edge. In the end, the Supreme Court made a pronouncement. I think a judge doing its work will basically just look at the law the way it is. And this is a matter of evidence too. And I think, again, for this particular one, actually, it's a matter of evidence, it's a matter of legal principle. The complaint is about disenfranchisement.
Yes, it's a human rights action.
Exactly. So it's a matter of legal interpretation. And if the court comes to a conclusion that the action of the EC, or the inaction, rather, of the EC, in this respect, amounts to a disenfranchisement on the basis of which, per all the principles of proportionality and balance, the court thinks that the election there cannot stand the way it is, the court will go ahead and make a pronouncement. I don't think that judges, when making decisions, particularly in respect of constitutional rights, are necessarily affected by the political pressures in Parliament. The NDC and MPP have been doing this for the better part of almost 30 years, or something like that, and it will continue to happen. It is true that this Parliament is like no other. It is true that the stakes are so high that potentially a government in the making may be stultified from day one and may not be able to do its work moving forward. And so the stakes are indeed very high. Yeah. But at the same time, judges do what they have to do. And
this is really my very final question. The suggestion again is that he has to be served with the processes, the order of interim injunction, and then the repeat application. Supposing he doesn't make himself available to be served and everything else, and then on the day he goes to Parliament, some say he might even, pay a blind eye to whatever if he's served, and decide that for the purposes for his government and party, he would rather break the law and suffer whatever punishment than obey the law for his party not to be able to elect a speaker.
Yeah, you're making a lot of assumptions.
Yes.
And some of them are dangerous. And you're putting me also in a very compromised position of advising lawyers on what they should do, which I'm highly constrained to do. But there's a way you serve parliamentary notices. There's a way you serve parliamentary processes. So without answering, I'm just saying it like that. That's the way you serve parliamentary notices and parliamentary processes. And there are two key actors in Parliament who receive these notices and processes in respect of Parliament. And once they receive them, whether you've been served in your personal capacity or not, when you show up there, you'll be notified. I'll leave it like that, but I'm sure the lawyers know what to do.
Okay.
Something.
Yes, your very final words. You are taking leave of us.
Let me ask about what happened on July 8th, 2020, when parliamentary constituencies instrument was laid and certain parts were carved out of Jasikan district. So what Mrs.
Jean Mensah.
No,
or
or something.
Yes, Professor Margaret Kweku.
Yes, she was part of the delegation and everything. He was a member of the committee in Parliament. The electoral areas they are talking about refers to Buem, but not Hohoi. Yeah.
Okay. Well, we leave that to the court.
We leave that to
right?
the courts.
Okay. And there's a Supreme Court judgment on that subject.
Yes.
And many people have referred to the Supreme Court saying the Lolobi, Santrokofi, Akpafu are not part of Hohoi, but I'll invite them, read the judgment itself in full and see what the court did. Thank you. We'll take a break here.
Thank you.
All right.